The concept of a public charge has been part of immigration law and it is very important for immigrants. To understand what is public charge? Where does public charge stand now? What it means to your immigration journey? And what precautions you need to take not to violate public charge rule.
Visit us at Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
Now let's get into the video and find out what's new in U.S. immigration. This guidance defined a public charge as someone who is primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or institutionalization for long-term care at government expense. So where does the public charge rule stand now? During the Trump administration, the public charge rule was dramatically expanded to reduce the number of people who were eligible for green cards and other visas, by redefining what made them dependent on government benefits, or likely to be in the future. There were two versions of the regulation released in 2019, the DHS Public Charge Rule, which applied to green card applicants within the United States, and the DOS Public Charge Rule, which applied to those outside the United States. Neither version of the 2019 rule is still in effect. The 2019 DHS rule was halted by the Biden administration on March 9, 2021, while the analogous DOS policy was paused indefinitely on July 29, 2020 due to a court order. The Biden administration withdrew the 2019 rule in 2021, and proposed its own version of the rule in February 2022, which it finalized on September 9, 2022. The 2022 rule mirrors the 1999 interim field guidance by defining a public charge as someone who is primarily dependent on the government for subsistence, as demonstrated by either A. using public cash assistance for income maintenance or B. institutionalization for long-term care at government expense. Specifically, this includes Supplemental Security Income, SSI, Temporary Assistance for Needy Families, TANF, commonly known as welfare, State and Local Cash Assistance, sometimes called General Assistance, Medicaid or other programs supporting long-term institutionalized care, such as in a nursing home or mental health institution. So what does public rule mean for an immigrant? Applicants are not required to submit Form I-944 or DS 5540 when applying for permanent residency or a visa. The guidance used by the government since 1999 to decide whether someone is likely to become a public charge has been finalized into formal policy through the government's agency rulemaking process. Let's understand a bit about public charge rule history. The public charge concept was first established by Congress in 1882 in order to allow the U.S. government to deny a U.S. visa to any person unable to take care of himself or herself without becoming a public charge. Congress updated the law in 1891, preventing the entry of anyone who is likely at any time to become a public charge. Neither law, however, defined what public charge meant. In 1999, immigration officers have adopted the guiding principle that a public charge is someone primarily dependent on the government for subsistence, as demonstrated by either A. using public cash assistance for income maintenance or B. institutionalization for long-term care at government expense. Specifically, this has included 1. Supplemental Security Income, SSI. 2. Temporary Assistance for Needy Families, TANF, commonly known as welfare. 3. State and Local Cash Assistance, sometimes called General Assistance. 4. Medicaid or other programs supporting long-term institutionalized care, such as in a nursing home or mental health institution. Under this policy, very few immigrants have been denied green cards on public charge grounds, for two primary reasons. First, Congress has already barred most immigrants from using welfare, so prior use of these benefits is out of the question. Second, Congress requires that most green card applicants have a financial sponsor, typically a U.S. citizen spouse or other family member, who can demonstrate sufficient income to prevent future dependency on government benefits. That income threshold is defined in statute as 125% of the federal poverty guidelines, currently $21,137 for most couples without children. That's why, for the past 2 decades, the vast majority of visa applicants have been able to avoid the public charge roadblock by submitting a financial sponsor's affidavit of support, accompanied by evidence of meeting the statutory income threshold. During the Trump administration, DHS announced a new proposed public charge regulation on September 22, 2018 and published a final regulation on August 14, 2019. This 2019 public charge rule went into effect on February 24, 2020. It was met swiftly with multiple challenges from states' attorneys general, as well as immigrant and civil rights advocates. The 2019 DHS rule was halted by the Biden administration on March 9, 2021, while the analogous DOS policy was paused indefinitely on July 29, 2020 due to a court order. On April 9, 2021, the Ninth Circuit Court of Appeals denied Republican states' efforts to resurrect the 2019 rule. Biden administration released a proposed public charge rule for DHS on February 16, 2022, which largely codified the 1999 interim field guidance, narrowing the extremely broad definition of public charge found in the 2019 rule to a more simplified and fair standard. The final rule was unveiled on September 8, 2022, and is scheduled to take effect on December 23, 2022. Understanding details on what changed under the 2019 DHS public charge rule? Under the final regulation, DHS created the following new criteria for denying a green card application from within the United States. 1. Prior use of certain government benefits. Instead of limiting the definition of off-limits government benefits to welfare payments and subsidized long-term institutionalization, the policy expanded the definition to include a wider range of common government benefits. All of the status quo benefits listed above, SSI, TANF, General Assistance, and Long-Term Institutional Care, Supplemental Nutrition Assistance Program, SNAP, commonly known as food stamps. Section 8 Housing and Rental Assistance. Federal housing subsidies. Non-emergency Medicaid benefits, with exceptions for children under 21, people with disabilities, pregnant women, and mothers within 60 days after giving birth. A public charge denial would be triggered if someone received one or more of the above public benefits, for more than 12 months in aggregate within any 36-month period. Receipt of two benefits in 1 month counted as 2 months. 2. Likelihood of future use of government benefits. Although the following general criteria are defined by Congress, DHS greatly expanded the number of specific factors that immigration officers had to consider when determining whether a visa applicant was likely to become a public charge at any point in the future. Age. Applicants could be denied if they were younger than the minimum age for full-time employment, 18, older than the minimum early retirement age for Social Security purposes, 61, or otherwise at an age that impacted their ability to work. Health. DHS scrutinized any medical condition and assessed whether this condition could affect the applicant's ability to work. 3. Family size. Having more children or other dependents could increase the likelihood of a visa denial. 4. Skills. DHS determined whether an applicant had adequate education and skills to either obtain or maintain employment, if authorized to work, by looking at employment history, high school degree and higher education, occupational skills, certifications, or licenses, and proficiency in English or other languages. 5. Financial status. Above and beyond looking at an applicant's income and assets, see below, DHS assessed credit history, credit score, and financial liabilities, plus whether the applicant had private health insurance or enough resources to cover any reasonably foreseeable medical costs that could interfere with work or study. 3. Insufficient financial resources. Even if an applicant had never used government benefits in the past and met all the above criteria to demonstrate low likelihood of using benefits in the future, they could still be blocked by an entirely new requirement: personal financial resources. DHS required a new form called the Declaration of Self-Sufficiency, Form I-944, to accompany most applications for green cards. This form collected information intended to help immigration officers determine whether the applicant was a public charge under the new, more expansive criteria outlined above. Who was affected by this policy change? Green card applicants. The public charge rule applied to the vast majority of applicants for green cards, permanent residents. This included green cards based on a family relationship to a U.S. citizen or lawful permanent resident, sponsorship by a U.S. employer, temporary visa applicants. Moreover, DHS applied some of the new public charge standards to a wide range of temporary, non-immigrant visas, whenever a visa holder in the United States needed to extend their visa or change to a new visa category. This included the H-1B visa for skilled workers. Again, it's important to understand that the great majority of people applying for an extension or change of temporary, non-immigrant visas are not even eligible for the very benefits that the DHS public charge rule sought to penalize. Though there is exemptions, the public charge rule did not apply to visa applicants whom Congress has exempted from the public charge test, such as refugees, asylees, individuals who had experienced domestic violence, and other special categories. What about permanent residents seeking U.S. citizenship? Changes to the definition of public charge could have ultimately expanded the ability of DHS to deport some immigrants who already had green cards, lawful permanent residents. Congress states that a permanent resident can only be deported on public charge grounds within the first 5 years of obtaining their green card, and only if they became a public charge based on circumstances that existed before they obtained their green card. In practice, given the constraints set by Congress and court precedents, plus the fact that recent green card holders are typically ineligible for welfare, very few green card holders have been deported on public charge grounds. For example, as part of the marriage-based green card process, the spouse of a U.S. citizen first obtains a green card, and then must wait 3 years to apply for U.S. citizenship, naturalization. DHS offers a fee waiver for low-income applicants. But if use of this fee waiver suddenly counts as a government benefit triggering a public charge finding, it's possible that the permanent resident spouse of a U.S. citizen could then be deported. What about visa applicants from abroad? It's important to note that the DHS public charge rule described above was a regulation issued by U.S. Citizenship and Immigration Services, USCIS, the part of DHS that processes green card and temporary visa applications filed within the United States. Visa applicants abroad must file through their local embassy or consulate, in a process largely controlled by the U.S. Department of State. At first, USCIS and the State Department followed the same relatively narrow definition of public charge. In January 2018, however, the State Department changed its policy to expand the scenarios when a consular officer may deny a visa application on public charge grounds. This change was made through revisions to the Foreign Affairs Manual, which guides decision-making by consular officers. Although that means the changes were effective immediately, they were also less specific than what DHS is contemplating through its more slowly moving regulatory process. What about sponsors of green card applicants? Separate from the actions described above, in May 2019, the White House issued a presidential memorandum directing a dozen cabinet secretaries to step up punitive actions against U.S. citizens and permanent residents if their sponsored immigrant family members receive public benefits such as food stamps or Medicaid. For more than 2 decades, U.S. law has required that in order to sponsor a family member for a green card, a U.S. citizen or permanent resident must sign an affidavit of support, which is essentially a contract with the federal government promising to maintain the sponsored immigrant's household income at no less than 125% of the federal poverty guidelines. If the immigrant ends up using certain public benefits before becoming a U.S. citizen, then the government has the right to recover the cash value of those benefits from the sponsor. Until now, however, there have been few such recovery actions by the government. By directing several federal agencies to vigorously pursue any possible recovery action, the White House order caused concern among family-based green card sponsors. It's important to remember, however, that relatively few green card holders are eligible for public benefits in the first place, and therefore most green card sponsors were unlikely to be harmed by this order.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!